Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And a very good day I wish to Madam Ani Munirah. And welcome to my video presentation regarding the case that had been chosen for me, which is a Wong Fo Hin against public prosecutor. In my understanding, when I read the case was also concerning about the character evidence of the accused person. Therefore, as my introduction, I would like to explain the two categories under the character evidence, which are first is the good character, second is the bad character. The good character is admissible under Section 53 of the Evidence Act 1950, hearing after call EA. And the instant case of Habib Mohammed, a man's character is important in explaining his conduct with regards to the charge in order to determine his innocence or his criminality. Also, in the question of punishment, the accused is allowed to prove his general good character in order to reduce his punishment imposed upon him. However, for the bad character evidence, it is inadmissible evidence under Section 54 Clause 1 of EA. However, there are several exceptions to the admissibility of bad character evidence under the paragraph A, B and C of Section 54 Clause 2 of EA. Paragraph A of the Section 54 Clause 2, the bad character evidence is admissible as accused was allowed to be asked about his misconduct, which had already been admitted. And under paragraph B, the prosecution was able to ask questions which reflect to the accused's bad character if the accused attempt to establish his own good character. And the lastly is under paragraph C, the cross-examination on the accused's bad character or the previous commission of offence is allowed when the accused started to give evidence which against his co-accused. Moving on to the details of the Wong Fo Hin case, in the early of May, when the appellant had been interfered with his own daughter, and at the time the wife had complained to orang tua about the incident, and the orang tua stated that if this occurred again, the matter will be reported to the police. And 3 months later, particularly on 7 August 1963, the appellant had again one incestuous relationship with his own daughter, and the wife reported to the police about the second incident, and unfortunately, once the wife returned to the home, the daughter was not there, and 2 days later, the daughter's body was found in a well near the house. The main issue in this case was whether evidence of incidents in May and evidence before the daughter's disappearance, which suggested an incestuous relationship between the appellant and his daughter, amounted to evidence of bad character of the accused in order to constitute the murder, were irrelevant and thus inadmissible to be presented before the court. Therefore, the court held that evidences of 2 incidents were admissible. Evidence for the first incident concerning the interview with the orang tua shows how strong the motive must have been when the wife went off the night on the first time on the time that the second incident happened. The court also agreed to the fact that the appellant was likely to be very concerned that this time, which is the second incident, would be a police investigation and the daughter was a very, very important person to be interviewed with, and this can be a very dangerous situation to the appellant. Therefore, in the end of the case, the appeal was dismissed because of the evidence presented before the court was relevant to become admissible evidence under section 54 clause 2 of EA, and the court affirmed the conviction and sentence of the accused. Reflection, lesson learned from the case. Evidence obtained from the two respective occasions were relevant under paragraph A of section 54 clause 2, in which exception to the rule that cross-examination of the accused suggested to his bad character is irrelevant. In this kind of situation, it allows the accused to be asked about the previous misconduct which had been already admitted in chief of the prosecution case, usually evidence related to the similar fact evidence. As in the instant case of Wong For Him, his first offence already admitted in the trial, and therefore the bad character evidence of the appellant would be relevant and admissible for the charge of murder against him. And it is not the business of the court either to try the man or the accused person himself, but the court just only to try the case that had been presented before it, and the accused had been protected under the shield of section 54 clause 1 of EA. However, there is no exception to the rule that every rule has an exception, and as such, in the case study, provided that the evidence of bad character is admissible and relevant to be presented before the court, because the accused was allowed to be asked for his previous commission of offence admitted in order to establish his bad character evidence. Thus, the evidence of bad character is relevant under paragraph A of section 54 clause 2. Moving on to the recommendation. Under the recommendation, there is one question that I think important to be pondered with, which is whether it is possible to evaluate the character evidence objectively without being biased. The judge's perception to the good or bad character of the accused person may be free of bias because it may influence the decision making by the judge, and the way of judge to consider the good or bad character of accused person must be changes over time in order to ensure for the best judgment for the parties in dispute. However, because in some occasions, different colored views towards the accused person as a result of bias against the accused by judges, it will lead to the branding of the parties as a person of bad character. And I think that is all from me about the case review of Wong For Him against public prosecutor. And thank you very much for listening until the end.